to be honest, I think anybody that's being fair about this would say this is a confusing situation. What we're talking about is the Biden administration's mandate that requires private employers that have more than 100 employees or more, to have in place a system where vaccinated employees would show their vaccination card. Non-vaccinated, unvaccinated employees would be required to do a weekly test.
The question at hand is, how does this work for an employer, and how does this work for the employee?
Right.
In a situation that we're coming on to in, just under 2 weeks? Under 2 weeks. I mean, you're even less than that. 10 days or so until this is supposed to go into effect. And really, the rules are blurry. There's not a lot of oversight here and clarity, whether that's coming from the Supreme Court and what's going to happen there, or whether that's what's coming from even just the Osha rules.
The rules suggest that you need to impose a mandate on your employees to be vaccinated, or there's an exception allowable if they are subject to weekly testing.
At their expense.
At their expense.
It's just confusing. And the part of the problem with taking the calls, and I'm glad we're doing it, Logan, is some of these we just don't know the answer to.
And for it's obviously for employers over 100 is the mandate. But,
yes, but not in one location.
And no one's really even clear what that 100 means. Is that 100 people? Is that 100 if you got guests, if you have part-time employees? It seems very vague, and I think that's a problem. They're concerned.
And the penalties are gigantic.
There's a lot of people with 100-ish people working for them.
100-ish?
Yeah, like there are. That's
about as confirmed as their orders. We have about 100-ish.
That's a big business, but that's not a gigantic business. That's not McDonald's employing hundreds of thousands. You're talking about 100 people to do this. It could be a very
We only got 50
burden.
seconds left there, but there are employers that are covered by this thing that do have 100,000.
Yeah, Will just said the requirements are vague, but the penalties are not.
Yeah, that's...
Well, not only that, you also have the situation where the penalties have been ramped up.
Yes.
Just for this particular issue vis-a-vis other issues in the workplace.
Let me tell you what this means. We're really fighting hard to get clarity. We did ask for a stay. We've asked for a stay.
We did. Yes.
So the problem here is that the stay, it wasn't denied, it was postponed. And the law goes into effect. So how do you read it?
The employers have to begin all of the work necessary to comply with OSHA before the Supreme Court will even hear argument in this case. And then, as you know, then we have to wait for a decision after oral argument.
3 days to 3 weeks or 3 months. We have no idea.
Right.
So, and it's only a decision on the stay. So then if the stay is granted, it goes back to the courts, Logan, to determine it on the merits.
An administrative stay just simply says, stop. Hold everything as it is. The law does not go into effect. The things that the Fifth Circuit decided in granting the stay in effect. The overruling of that by the Sixth Circuit is reversed for the moment, administratively, until we can hear from the government, December 30th, until we can hear a reply from the petitioners, that includes us, January 3rd, until we can have oral argument, which is January 7th. He could have said, just everybody stop in your shoes, stay still, and let's figure this thing out before everybody's scrambling around to figure out whether they get tested, how they get tested, how much it's going to cost, what this is going to be, what that's going to be. But he did not do that.
The thing I just cannot get my head around, Logan. I've been doing this for 40 years. I mean, Abby said that, you would know better than anybody. I mean, it's the truth. You get administrative stays, like Annie said, are not complicated. You just, they're hearing the argument in the case 3 days after it goes into effect. Issue an administrative stay, decide the case quickly. They did Bush versus Gore in 2 days. And you have a decision by the 10th, and then we figure it out. And then give us a week to figure out how to implement it.
It certainly throws everything up in the air because, in essence, employers need to prepare for the full enforcement of this mandate as of January the 4th, 2022, and then the Supreme Court will actually hear the case, or at least a case surrounding the stay on the 7th.
We've got a brief due in this case on January 3rd. The government's brief is due on the 30th. Oral arguments are on the 7th. The law goes into effect on the 4th. Is this complicated enough? Yes. Could have they made it less complicated? I've been doing this for 40 years, so I'm going to say it. Yeah, they could have made this a lot less complicated. I've been doing this for 4 decades. There's an easy way to do it. They should have issued the stay.